Marita, we can start.
Yes, ma'am, we can start. So, Sujit, sir, if you're ready to start, can we start, sir? Surjit Singh, sir, can you please unmute yourself, sir? Confirm.
Sujit sir, can you unmute yourself, please? Sir, can you unmute yourself? We cannot hear you.
अभी देखो आपको आवाज समझ आ रही है मेरी आ रही
Marita, we can start.
Good. Good morning. I'm Marietta, Assistant Director, NACIN Mumbai. On behalf of NACIN Mumbai, I extend a warm welcome to all participants to this weekly series titled Vigilance Dialogues. Hope you're all doing well. I would now like to invite Ms. Jyoti Agrawal, Additional Director, NACIN Mumbai, to please address the participants.
Good morning and welcome to this weekly series. I would like to welcome our faculty today, Shri Surjit Singh. He serves as Director, CVC. As you all are aware that NACIN Mumbai has started this weekly series every Tuesday. And last two sessions, online sessions, were taken by Shri Prabhat Kumar, Principal ADG, NACIN Mumbai, and wherein he covered the topics complaints handling and preliminary investigation and preparation of charge sheet and conduct of departmental inquiry. Taking it further, we have invited esteemed faculty, Surjit sir, who has a wide experience working in this organization, and no one could be better than him to make us understand what are the important parts of departmental inquiry, what is to be kept in mind, what are the do's and don'ts. So I'm very thankful that he has taken his time out. And please, Ashish Nagar, please unmute, please mute yourself. Thank you. So I'm very thankful and we are privileged to have him here. And before moving ahead, I would formally introduce her, and I hope this series is benefiting you all. We are also looking forward for your comments, for your feedbacks, or any issues or any questions you have with respect to the series we are doing. And lastly, I would like to thank that we are getting such a overwhelming response, and officers from all the customs, GST formations, and other formations are joining and attending this. Thank you, and over to you, Marita.
Thank you, ma'am. It's my privilege to introduce our speaker for today. As ma'am said, we have with us Shri Surjit Singh, sir. He is Director Retired from the Central Vigilance Commission. Sir joined CVC on being selected through the Union Public Service Commission. Sir has a wide and deep understanding of vigilance setups in various central government organizations. Sir has conducted sensitive and high-profile investigations while working as Deputy Director Vigilance in MCB for 3 years. He has also dealt with policy matters related to vigilance administration of the government and the Commission, has handled a wide variety of vigilance cases in different sectors, submitted over 100 departmental inquiries, and has served as Chief Vigilance Officer of the Commission. Additionally, SIR has also handled administrative matters, including human resources, establishment, personnel, and general administration for about 12 years in various capacities. SIR's numerous achievements include organizing the Golden Jubilee celebrations of the Commission in February 2014, which was attended by high dignitaries like the Honorable President of India and Prime Minister of India and the Chief Justice of Supreme Court, amongst others. SIR has contributed to a coffee table book and documentary production and has assisted in organizing the executive committee meeting of the International Association of Anti-Corruption Authorities. Post-retirement, SIR's assignments include serving as advisor training in SAFE, advisor vigilance to the CMD, NBCC, conducting departmental inquiries and investigating serious and sensitive issues of a ministry. SIR has also been a faculty in training courses for chief vigilance officers and has delivered lectures and workshops on vigilance administration for various government organizations, PSUs, banks, and training institutes. So with that, I would like to welcome you, sir, once again, and request you to please take the session forward. Thank you.
Good morning, my friends. So I request that if you can keep your video on, I would be grateful because I want to have a eye-to-eye contact with you. If you can do it, it would be better for me to talk to you. I request whosoever is possible to start their video on, it would be possible for me to talk properly. I request if you can. Yes.
Sir, please requested to switch on your videos.
Yes, because I purposefully avoided using PPT because when you start using PPT, the contact is lost. So the purpose is only to see that when we talk to each other eye to eye, we have the better communication take place. So Mr. Prabhat Kumar, I think, has also joined, my friend. I'm able to see him from here. See, the topic chosen is today's conductable departmental inquiry. Before that, I'm told that you have already covered preliminary investigation and charge sheet. The question, should come to our mind that why this inquiry is necessary. See, why there is inquiry in this, we are talking about conduct of departmental inquiry. There is one article in the Constitution, this is Article 310 of the Constitution of India. I'll just read out to you that part. Why that is important in the sense that this says, except, yes, kindly be careful about what I'm reading out from the Constitution itself. Except as expressly provided by this Constitution, every person who is a member of a defense service or of a civil service of the Union or All India service or holds any post connected with the defense or civil post under the Union holds office during the pleasure of the President. This Article 310 is very much part of the Constitution as on date also. This says, except as expressly provided by this Constitution, any person who is holding a civil or defense post under the Union is in service during the pleasure of the President. So the doctrine of pleasure of President is very much in part of the Constitution. That means if this Article 310 is allowed to be operated, that means there is no need for, as long as the President is comfortable, happy with your services, you are in service. If he's uncomfortable, he's unhappy, then that article says that you can be given a go by. Thank you very much. So show-cause notice can be given to you and the person can be dispensed with. But this is not the case. We are talking about a charge sheet. We have talked about the conduct of a detailed procedure as to how to conduct inquiries to be conducted. Then what is significance of this Article 310 in the Constitution, which is as on date retained? See, why this article has been retained all along, and it's as on date is a part of the Constitution. This is, if you carefully look at the wording, it says except as expressly provided by this constitution. Mean if there is any other provision in the constitution that will regulate operation of this article. If any other provision in the constitution there that may regulate operation of this article, if this is not there, then this provision will take place. Mean the 310 would have taken place, then there was no need for a detailed inquiry procedure as for which we are talking about today. Then article 310 higher and far would have been, policy would have been served here, would have also been operated here. So the question comes, then why this article is retained? This enables us to remind us that there is a master-servant relationship between us and the president. So president is the master, we are a servant. You may be holding a very senior position in the office, you may be to the Secretary Government of India, you continue to be called a public servant. So the title servant is attached to us, all of us, irrespective of any organization which we are placed or working. You may be employee of a state government, you may be employee of a PSU, you may be employee of a bank, you may be employee of a central government. So the fact that servant title is attached to us, the servant is required to obey the rules, regulation framed by the master, and master is the president. And you must have heard there are conduct rules which are applicable to us. The conduct rules, CCS conduct rule 1964 are applicable to all central government employees except already officers. So these are as a public servant, we are required to follow the regulations as available in CCS Conduct Rule 1964. And if any failure, any violation of the conduct rules is likely to be visited with any kind of punishment depending upon the gravity of the irregularity which will be committed by the person concerned. Now I'm coming back to the purpose is that Article 310 remind us that there is a master and master is competent to take action against us if we do not conform to the laid down rules, regulations by him. So the question is, there is an Article 311 of the Constitution of India, which regulates operation of Article 310 of the Constitution. 311 of the Constitution is are you aware of this? What is the significance of Article 311 of the Constitution? If somebody is aware, please. If somebody has gone through the process of conduct of departmental inquiry, if somebody is aware, please respond. Have you ever heard Article 311? There are a lot of people.
Participants.
I request people, I want people to be responsive because the purpose would not be served if I keep talking and you don't respond. I expect question from you. That only can happen if you participate. Otherwise, and the purpose of having this kind of session would not be served. Let us discuss, you ask any issue, you come, the purpose is to participate, have a dialogue where we exchange our views. You can have a view, I can have a different view, at times it can happen, but ultimately we have to talk to each other. Except Mr. Prabhat Kumar and other people who are aware of everything, I request the participants, there are 41 participants who have joined. I request them to please say yes or no.
No, sir.
No. Okay. बोलिए कोई दिक्कत नहीं है. It's not important that if see many of you have not been exposed to this kind of thing, so it's better to ask. Article 311 of the Constitution talks about. This says first provision says no person who is a member of a civil service of the union. Sorry. This says a person, yes, there are a lot of participants here. I'm happy to see them. Yeah. A person who is a member of a civil service of the union or an all India service or a civil service of the state shall be dismissed or removed by authorities subordinate to the person he was appointed. First provision of the Article 311 say a person holding a civil post under the union, all officers of the customs are holding a civil post under the union. And this says that you cannot be dismissed, removed from service by any authority who is subordinate to the appointing authority. Means if you have been appointed by the president, no other authority can dismiss or remove you from service. The concept of appointing authority in regard to disciplinary proceeding have been recognized in our first provision of Article 311 of the Constitution. Parts 2 of the 311 says no such person means a person holding a civil post under the union shall be dismissed, removed, or reduced in rank, etc. Means these are the major penalties. They cannot be dismissed, removed, or reduced in rank unless after inquiry is conducted and in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of these charges. At second provision of Article 311 talks. First, if the competent disciplinary authority or the appointing authority wishes to impose a major penalty on any civil servant for the violation or the irregularity which have been committed by him, then there is an obligation on the part of the appointing authority to inform of the charges. The concept of issue of a charge sheet is derived from Article 311 of the Constitution. Means it is an obligation on the part of the appointing authority that you have to issue a charge sheet. Unless you issue a charge sheet, you cannot be removed or dismissed from service. There is only exception. There are 3 exceptions to Article 311. I will just mention about them, and which has been incorporated under Rule 19 of the CCSC Rule 1965. They say there is no need for an inquiry in 3 circumstances. A, where a person has been convicted by the court, there is no need for a conduct of a detailed inquiry. Secondly, that it is not practically possible to conduct the inquiry. Okay, when you see there, you will see that. Okay. So second exception is that when it is not practically possible to conduct the inquiry. So what are those circumstances? Can we say? First is that a person has been convicted by the court for any criminal misconduct. Then there is no need for conduct of inquiry. The procedure is that only a show cause notice is required to be given that the disciplinary authority or competent authority propose to impose this punishment. You may want to, whatever the views you want to express your views, you may express, but there is no need for inquiry. The person can be straightway dismissed from service depending on the gravity of the criminal misconduct established against him in the court of law. The second exception is that when it is not possible, practically possible to conduct an inquiry. The circumstances are like that, where the inquiry officer is not even possible. The victims are being threatened. There is a violence. The charge officer is not allowing those conditions. They're creating those conditions where it is not possible to conduct a fair inquiry. those reasons have to be recorded, and if the disciplinary authority competent is satisfied that it's not possible to conduct inquiry, then the person can be visited with a major penalty without following the procedure of a detailed inquiry. Third exception is that when the person concerned has been found responsible for indulging in anti-national activities. When it threats to the security of a state, then there is no need for conduct of inquiry. The person can be straightway dismissed or removed from service. Except these three circumstances, three exceptions, there is a need for, there is a obligation, requirement, statutory requirement to conduct a detailed procedure of conducting departmental inquiry, follow the detailed procedure of conducting departmental inquiry, which we will be discussing in the time to come. So I have explained to you why the master-servant relationship requires that we have to follow certain code of conduct prescribed for us by the master. And if we do not follow them, they are liable to be taken action against them by the master. And then if the master wants to impose a major penalty of removal, dismissal, or any other major penalty, then there is a requirement, there is an obligation on the part of the master, that is the president, to follow a particular procedure for conducting the inquiry. That is, he is required to issue a charge sheet, and then he is required to appoint an inquiry officer, and then inquiry officer is under obligation to provide him a reasonable opportunity of defending his case. So the concept of charge sheet, concept of an appointment of inquiry officer, concept of providing reasonable opportunity is provided in Article 311 of the Constitution. 311 of the Constitution of India. So I hope I have tried to make my point clear. If anybody has an issue or any query with regard to this area, please speak out. And I've also clarified there are three exceptions when Article 311 will not prevail. There are two exceptions only when there is no need for conduct of a detailed inquiry. Anybody, I mean, I expect anybody may ask any question. Let it be a silly question. I don't mind. I mind that people should respond. People should react. कुछ भी बोलिए. It is not important. I am not. I mean, it's not कोई ज्ञान घर से सीख के नहीं आता. We only learn by this procedure. I request, but yeah, please.
I think the exceptions you have told us is clear.
Yes.
But I
Yes.
have one question.
Yes.
Wherein you have mentioned that when it is not possible to conduct an inquiry. So what
Yeah.
could be such cases? Could be it a riots or some kind of
Yes.
mob?
Good. Acha hua, because some conversation has started. This is what I wanted. See, the rule says when it is not practical possible to conduct. Now, practical, it has to be in really those situations. What could be? Can we think of a situation? Now, there is I have myself gone through a process where it was not possible for. There's only one exception, which I have also gone through. I've explained. There is a girl, woman, lady working in the Delhi metros. I think Delhi metro से कोई तो नहीं है यहाँ. Any party from Delhi metro?
No, sir.
I hope प्रभात कुमारी दिल्ली मेट्रो से कोई तो नहीं ज्वाइन किया.
नहीं. Please go ahead.
Because I will like to have a little courage.
No, please go ahead. No problem.
Because that will clear your doubts about this practical situation in which we not possible to conduct that work. So she was working in a HR department. Certain charges were framed because she has been not attending office, indiscipline, all kind of ML charges were against her. Even the general manager was threatened by her by all means. So nobody was willing to conduct the inquiry. Two people tried. Finally, I was also requested by some very senior person. We do not find any person to deal with the person. I mean, then I said that the presenting officer should be a lady officer. Then I accompanied one reliable person with me as a lady. I thought she will, because the situation was that what she will do, she will go to the resident of the inquiry officer and start creating shouting. I mean, she'll start shouting if we can't do the knowledge. There was a retired SP, he was appointed. She went to her residence, his residence, and he said, I don't want. So I said, let me take a chance. So first preliminary hearing, she did not attend. I again gave an opportunity. She said, okay. Then live video recording was conducted so that there is not possibility of any kind of, even the security staff, lady staff was around there. So that, because she had been the habit of creating nuisance and everything she would. So when she joined there, she brought along with one more person, or a lady person, along with her child. So I said, no, first of all, it's not appropriate that you should pick every person, because there is the person who's accompanying you is not a defense assistant, neither is you are only. No. She started arguing with everything, threatening. So despite the fact that it all being recorded on the camera, then she will come to the PO, she will level an allegation against the PO. So finally, she said, we somehow conducted some preliminary inquiry. No, she will say, I do not trust any person. Okay, fine. But you want to read, whatever you want to say. She was making allegations management. That is not a matter of concern for me as an inquiry officer. So finally, somehow we made her to sign the order sheet. That I think a lot of efforts. In the meanwhile, she made a complaint against the police that I was threatened to the local police. So local police she was after local police. Then I started, okay, then another hearing, again the same situation. So I gave in writing to them, because when there is the PO was threatened, the IOs, she got hold of my number. She will talk to me, her husband will talk to me, threatened me, all kind of things. So then finally, I have to say that it's not possible, practically possible to conduct the inquiry where the inquiry officer is threatened, the PO is threatened, the witnesses are threatened, and all kind of false allegations are being made against a inquiry officer. So situations are that way. It's not possible, it's not conducive circumstances are prevailing where a inquiry officer or a presenting officer or any witness can participate in them. This is the one example which I am trying to say. When practical situations are like that, when it's not humanly possible for any person to follow the procedure or follow the protocol. The DMRC still thought of taking another chance. Went another officer from the CVC retired. She went to her residence. She made a lot of scenes and all kind of fun. But I'm trying to say that the situations are there when the practically is not possible. I think these are the one of the examples which I gave it to you so that you can understand. Similarly, in a situation where the witness is threatening, all witness, physical violence there is possibility physical violence to the presenting officer, to the witness, or to the inquiry officer. Or you expect an inquiry officer or presenting officer to conduct their proceeding. So these are those have to be practically put in, they have to be recorded in writing. And those circumstances, taking into consideration those circumstances, the appointing of the disciplinary authority taken in view that there is and resort to exceptional procedure and dismiss or remove any other or impose any other punishment depending upon the gravity of the irregularities against. So this is, I hope I'm trying to make you understand the situation where it's practical, not possible.
Yes, sir. Thank you, sir.
Okay. Now, we have seen the situation where that there is a statutory requirement of conducting the inquiry. And the question is that reasonable opportunity, the Article 311 talks about reasonable opportunity. Reasonable opportunity has not been explained in the rule. No, what is reasonable? So reasonable will depend upon facts and circumstances of each case. But the courts have evolved certain norms. If those norms have been followed while conducting the inquiry, the presumption would be laid that the reasonable opportunity would be has been afforded. First, he says, charge sheet should be served because this is a part of the procedure. That first requirement of reasonable opportunity that the person should know what are the issues against him. What are the issues against him? He should know. Secondly, that he should be allowed to produce and lead evidence. Allowed to produce and lead evidence means that he should also be given the opportunity of having his own documentary or oral evidence, as the case may be, to produce, to prove his innocence. Are you getting me? That if prosecution or the management has made certain allegations, if the management has cited certain evidence against him in the form of documentary evidence as well as oral evidence of two witnesses, he should also be given the opportunity of producing his evidence, which he considers relevant to prove his innocence. His evidence could be of documentary, his evidence could be of oral, in the sense of oral witness, witness as the case may be. Third requirement is that he should be allowed to cross-examine the management witness. He should be not deprived. See, the point is this, is a fair opportunity. The opportunity has to be given, fair opportunity has to be given to the both the sides. The management side as well as the defense side. And lastly, not finally, nothing should be done behind the back of the charge officer. That all the proceeding which the inquiry officer is conducting should be done when the charge officer is available before the inquiry officer, and no question will come. There are certain situations I am purposefully creating, I will create situation for you so that you react to that. There can be situations. The normal procedure is that nothing should be done behind the back of the charge. Means that all proceedings should be conducted when the charge officer is available. But there are situations when despite all possible opportunities being provided to the charge officer, he does not avail those opportunities. The requirement is reasonable, not undue reasonable. The reasonable. You have to, the inquiry officer is required to give him due notice, give him due opportunity to participate in the inquiry. But he cannot, if the charge officer, despite all best opportunity being given to him, he chose not to avail them, then the IO, the inquiry officer, will be left with no option but to conduct ex parte proceeding. So ex parte, except those circumstances, the inquiry should be done when the charge officer is also available in the inquiry. I hope I'm trying to my point clear to you that the reasonable opportunity would be served, would be deemed to have been provided. A, when the charge officer has also been given the opportunity of producing his side of the evidence, mean that he should also be given the opportunity of producing his documentary and the oral evidence. Then he should also be allowed to cross-examine the evidence which has been produced by the management. Third, that nothing should be done behind the back of the charge. All proceedings should be done when the charge officer himself in the inquiry. Is it clear? Now, the charge sheet, the charge sheet has been issued. We presume that the charge officer has denied the charge. Then see the requirement of appointment of inquiry officer will arise after the charge officer has denied the charges or his explanation has not been found suitable or satisfactory by the disciplinary court. He has said something into it, but that has not been found valid. So there is need for conduct of a inquiry, and for that matter, the appointing competent authority will appoint an inquiry officer to conduct the inquiry. So how the inquiry officer will go ahead, I mean, how one procedure is required to follow, that we explain, discuss. Any questions so far from any witness, from any participants here? Prabhat ji को provoke करिए. I request
the participants to ask as many questions as possible. And because we rarely get such kind of expert faculty to come to our forum and share their wisdom. So anybody wants to take this opportunity to ask regarding anything, they are most welcome. Things आप मुझे बताइए कि when you say behind the back, so what do you mean to say behind the back in proceeding?
Behind the back means when the charge officer is not available. The technical meaning behind the back is see, all proceedings should be conducted by the inquiry officer when the PO and particular CO is available. I tell you now. I remember one case. I just remember one case. You had not heard of a situation where the PO was not available in preliminary hearing. Okay, CO was available. So I talked to PO, can be available online, because ultimately PO has to ask 2-3, these are statutory formalities, but if CO is not available, then you should know. The requirement is that if any proceeding by the inquiry officer should be done as far as possible, mean when the charge officer chose himself, you have given him reasonable opportunity to have a due notice to him, given him to see that he is able to participate. See, the inquiry officer is required to give him the opportunity. And if not second opportunity, to please join us. The charge officer in his wisdom found it right around is the wrong reason. He does not want to participate. Then it could be behind. Otherwise, you should conduct all the proceedings when the CO is available. That is called not behind.
Yeah.
Okay. Yeah, I'm not able to listen to you, Prabhat.
Yeah. Hello. Can you hear now?
Yeah, now I can hear you.
Okay. So, like suppose the defense assistant wants to be there. DA is present, but CO is absent. In that case, what will happen?
So defense assistant is there, but the CEO is not there. You mean to say? Defense assistant is there, but CEO is not there.
Yes.
See, I tell you, it is the normally there has to be exceptional circumstances. CEO is not physically able to join because the stakes of the CEO are there. Because CEO defense assistant is representative only. Okay, then It is CEO is not physically because of any reason beyond his control, physically he's not able to join. There has to be medical reason. And if he says, I allow my all responsibility for any proceeding, for any happening, my defense system would be, and that way. I will take responsibility. I will accept whatever the decision are taken by the defense system. I allowed only in one case. I remember the case. I can share the case also because there have been situations where the person was the charge officer suffered heart attack. But he wanted to continue with the inquiry, finish the inquiry, said he is retired as the executive director of a PSU. So he said, but I can join you through, that video conferencing. My defense system would be there physically. He gave in writing that I would be responsible for all the consequence and the action taken by the defense system. But the CEO was physically available through video. Otherwise, because the purpose is to that as far as possible, the CEO should be present in that body. Yeah.
Can you hear me or no? Can you hear me?
Yeah. At time I get your voice.
So now, the latest instruction of DOPT is that we should be using the online provision for conduct of the disciplinary proceedings. So what are those how can we use the online facility now? Can we?
Video conferencing. You are talking about video conferencing.
Can we talk?
Yeah.
Can we depose the witness through video conferencing?
Okay. During COVID period, COVID-19, DOPT issued the instruction regarding conduct of inquiry through video conferencing, but they have not given a detailed procedure what is to follow. I have conducted many cases of through video conferencing. See, the purpose is that requirement is the reasonable opportunity. First, second requirement is that the CEO should participate and should be able to satisfy with the procedure which we are following. Okay. The DOPT, while issuing the video conferencing procedure, has not issued any detailed guideline. But I can share I am following. First of all, there has to be consent from the CEO should be obtained that it has to be because the proceeding should be done video conferencing. And normally CEO should have no problem provided through video conferencing. He is able to listen and see what business being transacted by the inquiry officer. Now, what we do, there is a big screen we attach. To the laptop or to something, whatever being typed out should be seen by him. He should also have a video conferencing access where he can also assess. At time, the witness is also through video, joined through video conferencing. At time, VO is available, CEO is far away. What the question VO is asking, CEO should be able to listen. What is being typed out or what the IO is saying should also be seen by simultaneously. If we are typing out something, should be simultaneously seen by the CO, so that the purpose is that a transparent procedure, a system has to be involved where all the stakeholders are able to join together and see that the business being conducted in a fair and transparent manner, and all have the access to the to the system which we have followed. This is what I do. For example, a witness has given is a statement or deposition. What I do thereafter, I send that part to scanning to his email. He go through the process, if some any correction carried out, and then send back me scanned, signed, duly signed. I signed it and sent thereafter, scan and send to the PO and the CO for their reports. The purpose is only to see that a transparent procedure is followed, where all the participants are available to see that business is being transacted in a proper manner. The purpose is to see that the business should not be conducted in such a manner where all are able to see together. So this is what I try to follow. Recently, I conducted an inquiry against the Jawaharlal University officer, professor. The witness joined from the I think your service now is for income tax. One witness, it is from Ahmedabad. So he was a potent witness. He was a finance officer there. He was a principal commissioner, I think, presently there. So he joined through because so that recorded it was sent to him. He sent back. So that is in protocol. This is somehow I have evolved. The purpose there is no laid down guideline by DOPT or by the CVC, but procedure. The procedure should be such where the CO or the PO should not have any kind of problem. And what we are following should be seen, I was following should be seen by both departments. This is what
just one more second I wanted to ask. Like in the situation, how do you take the signatures of the PO and the CO and the defense assistant and the IO will sign ultimately?
I prepare an order sheet and send to all the scan it, and send to all the authorities. They sign it, scan it, and send back to me. Finally, I sign it and then I send to them, scan it and send to them all the way. This is the procedure.
And one more question I wanted to ask regarding the ex parte procedure. Like, how do you decide to go ex parte?
See, now I tell you, there's nothing as such written in the rules that in this situation ex parte should proceed. But the requirement of the procedure is reasonable opportunity. Okay. When you get, first of all, the notice to the CEO should be reasonable, that it will be adequate time given to him that he should join. Somebody is in, for example, you are conducting an inquiry physically. It's not do video conferencing. Now, video conferencing can also remove that because he's unable to join because he can join through video conferencing. If somebody has to join physically, somebody is posted in Chennai, he has to come. He has to get a flight. You have to give him some time so that he may have able to join. Number two, there is a problem in his office because of official requirement. He has to be present. If that request comes, you have to consider that. Then thirdly, that you have to ensure that verify and satisfy yourself as a inquiry officer that the CEO is willing to participate, but because of the circumstances beyond his control, he is not able. Sometimes you have to postpone it. The purpose, if there is the willingness on the part of CEO is available, then you must see that even if there is some delay, you must see that CEO participates. If one opportunity is given, okay, because of certain reason he is not able to join. Second opportunity, you are again a reasonable opportunity. Now I have give you example. I remember one case here. This is what I'm saying. Key situation where you have to resort to ex parte. I went to Indore and then PSU. The second, it was second opportunity. Due notice was given. The CEO took advance from his office. He was on duty, relieved by the controlling authority for joining in the inquiry. But then he landed at a particular place. The timing of inquiry is 11 a.m. It's a second opportunity. And in the first notice, we have indicated that if we do not join, there is a possibility of ex parte. We indicated that if you join, now this person's phone is switched off. We are trying to, we traced out his controlling authority says, yahan se to chale gaye. TA bhi leke gaye. Now the man is not visible. All of a sudden, we waited at again 2 hours. 2 o'clock, like enough. Now we record all those procedures which we followed. The man has been given that TA advance. He booked the ticket also. He is on duty also from the office. He has landed here. Now his phone is switched off. He has not conveyed any message to the PO or to any other means that or to IO. Then 2 o'clock, I started. Give me recorded and 5 o'clock he appears. Sir, मेरी तबीयत ठीक नहीं थी, मैं ऐसे हो गया, but he could have given a notice. The point I am trying to say that the IO has to satisfy himself that all the best option given to him. He is not giving a notice. He is not informing you. Then see the rule says that you have to provide him reasonable opportunity. But if he does not want to avail those opportunity, then IO must record those reasons in writing, and those if the reason are such that the IO has given more than adequate opportunity to participate in. Now he joins. Now, for example, if 5 o'clock he joins, it is the satisfaction of the inquiry officer. If you satisfy with the reasoning because of certain sign, you can start the procedure from the stage right from the very beginning. But if you feel that reasons, you have to record it. The IO is required to record it in writing that he is not satisfied. If he is satisfied, then he can recall. So my point is only those circumstances has to be where the IO feel that the CO has deliberately not chose to participate. So it can vary from case to case. But ultimately, the crux of the issue is that these circumstances should be really those circumstances where the reasonable conclusion can be reached that the CO did not want to participate in the inquiry intentionally. There have been many cases. 2 opportunities you gave, 3 opportunities. How many opportunities you can give to the CO? The procedure is that reasonable, not unreasonable. It is for him to participate. If he does not want to participate despite best opportunity given, what else you can do? But those reasons have to be recorded in writing in daily order sheet. And they have to be conveyed to the person concerned that we have gone for a party for these reasons. And a copy has to be sent to him, the order sheet has to be sent to the CO. He should know. And if now he joins back, he want to, and the IO feel that, okay, he want to condone, you can start. So it's all, up to the audience.
Yeah, one more question I wanted to ask. What are the
Yeah.
timelines for the departmental?
So the departmental body is 6 months. Now that's what I'm saying. On the one hand side, you have a time limit of 6 months. On the other hand, see, I tell you, where are those situations where the charge officer do not want to participate? They are very special cases. Where the CO knows when the IO is allowed to conduct an inquiry at the pace, the charges are likely to be. See, very clear. I have my experience telling me that the charge officer knows that I have to टांग पकड़नी है inquiry officer को आगे नहीं बढ़ने देना, because if I allow it, then the possibility of full damage charges be proved and he may be visited with a severe punishment. I remember one more case here. I will not name the organization. He is a very top level management officer. Presently, I will be not conducting the inquiry. He was the main person. All other his other participants have already been visited within his appointing. Some have dismissed the board. He somehow managed to drag on. Now he finally got a stay from court from an influency ground. The department was able to locate it. After 3 years, 4 years, they were able to finally locate it. Now the man is about to retire. He says, no, he planned such a way the man is now I am conducting inquiry when he is retiring in September. He is planned in such a way. So there are people, clever people who will not allow you to conduct the inquiry. These are those people who are likely, who are fully sure that otherwise in all other cases, the CEO participates. So you have to be very careful where you have to give a long rope. And see, you don't have to give a long rope to the charter, but reasonable, fair, while keeping in view the government guideline of 6 months. So, a balance has to be in such a way that you are not neitherly hurrying through the things, nor unduly unreasonable to the charter. So the thing can be, but at the same time, if a prudent inquiry officer will weigh the situations I mean, in the all the situation in the best possible manner, so that a correct view is taken by him. He should not be worried about what the CEO thinks. He should be worried that I am providing reasonable opportunity. That is, it should be concerned. He should see some people start disputing. For example, all documents you have been shown certified copy, printed copy. No, I want original. What original? Printed copy, Government of India has the stamp is there. You will challenge that also. But will you? So the point is only these are reasonable, not only.
So regarding this documentation, as you mentioned, so this is a very normal dispute that people say that I don't want photocopies, I want original documents. So what are the instructions in this regard? Yeah.
Major time lost is done only in the case of documentation, because the charge officer purposefully, where he knows that this case should not allowed to be continued on a pace, he will his first objection would be, I want inspection of the original documents. Inspection was done. Now, at time I tell you, the person is facing criminal trial in the court of law itself. These are those situations particularly. He knows that the original document are in the court, the person in the court. He knows that if there is a need for taking permission from the court, this all process will take time. Whether document is certified, even the certified copies by the CBI person or by the custodian, he will dispute. I want to know. Even the guideline from the DOPT that certified copies by the competent authority, by the custodian, or by the CBIC should be taken as good as original. But the CEO continue to. What he will do? If there is a very particular special document, which is a very, very important bearing on the complexion of the case, the CEO, the IO may allow permission, ask the PO to take the permission from the court, so that showing him the original document. Otherwise, certified copy from the custodian should be treated as good as original. But if you continue to, you can't help it. But you have to record in writing. These are the reasons which I tell you purposefully. These are purposefully. Reasonable, intentionally done to delay the process.
One more issue here. Like suppose the charge officer has given some defense document, and the defense document has been provided, which is certified copy. So the charge officer is satisfied with the certified copy. Can PO object to the certified copy and say, no, I want to see original?
I tell you, बहुत बढ़िया प्रश्न पूछ रहे हो आज. अभी तो आप तो पूछे जा रहे हो, पर हम कहीं पहुंचे नहीं है. नॉलेज सबके लिए ज्ञान की बात है. देखिए, the document by the defense are permitted by the inquiry officer if it's satisfied. A, that documents are traceable, identifiable. Number two, the documents are relevant to the charges framed against him. Once the relevancy is established by the inquiry, the IO is satisfied, it is the satisfaction of the inquiry officer. And if it's not satisfied, no, I'm clarifying the point, defense documents, because that the other participants also understand. As the management has produced a document from their side, the charge officer is also entitled to have his evidence. His evidence could be in the form of a documentary and or the witnesses. Now, documentary is the requirement. The onus lies on the charge officer to indicate the particulars of the documents, which documents he or which he wants, who is the custodian of the document. Thirdly, all that particular document is relevant to the charge of framed against him. So the document should be identifiable. Then custodian should be where the document, who is the custodian. Thirdly, the document should be relevant to the charge. Now, if his IO feels the document is not relevant, it is the IO is required to pass a speaking order, rejecting the request of the charge officer as to why the document is not relevant. See, it happened in one my case when I was CDA in the CBC. When the inquiry was transferred, one CDA of the commission has rejected certain documents of the witness and of the CO. He went to High Court then. The High Court said, no, the IO should pass a speaking order. I allowed 2 documents, 3 documents, I denied the speaking order. Why you don't consider the document to be relevant? So, and then there was no other issue. Once the document had been permitted by the inquiry officer, the custodian gave the certified copy. The custodian will never give you original because original are not. It's the custodian responsible to keep them safe custody. Certified by the custodian, then the PO should not have any objection with regard for the custodian has certified. Because nobody, custodian is the final authority in regard to the authenticity of the document. Because the requirement is authenticity of a document which has been listed in the inquiry. I hope I am trying to carry.
Yes. Regarding the documentation part only, one more question comes to my mind. As you mentioned, when we deny some defense documents, so normally we do that by passing an appropriate order in the daily order sheet. But the daily order sheet is normally an interlocutory order, it's not a speaking order, because relevancy is not a judicial procedure as such. So why the cat or the court insisted for a speaking order in this case?
See, I tell you, speaking order itself in the order sheet you can write because you can see the CEO. See, the point is the order sheet is a brief report of a transaction which has been conducted during that particular period. So you record that CEO produced this, wanted to have this particular document. You listen to the PO also, that PO says, you record and then you pass a speaking order in the order sheet itself. There is no further order required. Order sheet should indicate if you are rejecting it, if you are not rejecting it, itself will be that order sheet will be perused by seen by the court. It happened with me. I can narrate the case because there are numerous cases in the CVC which happened with me. These are situations because there was another case. I don't want to name an organization, like a PSU, very important PSU, and the Delhi located. I was CDA at that time. This person has been found caught red-handed by the CBI. He was he was facing a trial in the court in Mumbai, and the inquiry was being conducted. This man knew that if inquiry is allowed to be, no, this man would be out of job. So, what he will do, as I stated, that he will ask for documents which are not traceable, are not available, or vague. And if you reject it, I have rejected it, because when they are not, you can't trace out, what are the document. Finally, he will send in, the order sheet I used to finally, he led an allegation of bias against me that was rejected by the disciplinary. Again, went to the board of appeal against the court. Rule does not say, disciplinary authority has already applied the mind and passed, and I went ahead. The man went to the High Court of Delhi. I remember the case, I went for the regular hearing. The witness from Bombay came. This man does not participate, and at 11:30, 12, he appears. Sir, I went to the High Court of Delhi. You are most welcome. Bring a state from the court. I will stop. About 1 o'clock, I continued the procedure, and the evidence was being recorded. Sir, the court has stated, the court has not granted stay. Court has stated that the inquiry may not be concluded till the appeal by the board of adjustment. Yes, but I will, for the day, I will not participate. Now it is up to the court has not. Because if you have passed speaking order in the order sheet, the court will come to know that the IO is trying to give him an opportunity. He is not. Court will normally not interfere if the order sheet are explicit or clear. So finally, it could not. So what I'm trying to say is that order sheet should be recorded in such a way as in the, you must have seen the court. Court says both sides. I mean CO, PO, both sides. And then you pass a order saying that I have carefully examined both the and heard them. Listen to them. And whatever he is saying, you please record, put in black and white also. Record it. So that he has no reason to say that I have not been heard. I mean, whatever the views should be recorded. And then pass it order. Then no court normally will interfere. The problem is that the inquiry officer do not take this much labor. And here is the problem, and most of the inquiries are set aside only because of non-following of the procedure. Inquiry officer and technical violation committed by the inquiry officer. So I hope I have tried my point, please try to the queries which you have raised. Any other participant from him, because Prabhat Kumar साहब तो कैप्टन के साथ हमारी बात होती रहती है, अपनी बात हो जाएगी. बाकी participants भी पूछ लेंगे.
Sir, Ashwani has asked. Ashwani, can you unmute yourself and ask? From Mumbai Customs Zone 3.
Yes, ma'am. Thank you for the opportunity. Hello, sir. My question is.
Can you please आप वीडियो लगाएं? ऐसे तो पता नहीं चलता ना कौन है. Yes. Can you introduce yourself?
Yes, sir. So the question here is, sir, there is an inquiry going on, and the charged officer has requested for a particular piece of evidence, which is not listed as RUD along with the charge memo. But the charged officer knows that it is in the possession of the inquiry officer as well as the disciplinary authority. So charged officer has specifically requested for that piece of evidence. The agency which has conducted the investigation has passed it on confidentially to the disciplinary authority. So the question here is, will it be against the principles of natural justice if we denied access to that evidence?
First of all, I will only see requirements. The rule says CCSUC rule, which we are following. As I stated, there are three requirements. One is that I'm not talking about investigation report. Investigation report is not to be parted with to the charge officer. If you as an inquiry officer feel the document is relevant to the charges, if you consider relevant and then document is traceable, identifiable, then it is the IO may take a call for a longer term. Now, custodian does not want to share. Custodian says, no, I don't want. He can take privilege. That is the discretion of the custodian. For that, you have to pass a procedure for. But IO can do his job by if he or she considers the document is relevant. No, custodian feels the document cannot be shared for many reasons. It can play a role. The document eventually may not, but the IO will not be faltered. IO has done his job. As an inquiry officer, we should be concerned about the correct procedure which we are working for. Ashwini, did I satisfy your question? Answer?
Yes, sir. Yes, sir. Thank you, sir.
You should be only concerned. Now, custodian may take the privilege. If custodian's document is not available, non-availability certificate it can be given. So it's you do your part, let the custodian do their part. ठीक है? So आगे बढ़े आप?
Yes, sir. We can move forward. Yes.
So broadly, we have. I have not discussed. We have. The question which Mr. Prabhat Kumar has asked was related to an area which was then we have almost covered a lot of questions. Now I think we have to make a beginning. If we have up to which we can continue. कितने बजे तक कंटिन्यू कर सकते हैं?
Sir, it is 11:30 to 1, but as you say, we can make it for the 15 minutes, more 15 minutes. 1:15 we can do.
Okay, 15 minutes more. I will briefly touch upon certain things because now the 15 minutes I cannot do much, but at the same time, I will try whatever possible. Preliminary hearing, first preliminary when the IO is appointed, PO is appointed, CO is already available there. The preliminary hearing is conducted. Preliminary hearing, nowhere mentioned the CCA rule, but it is a concept which we evolved in CVC. Nothing. Even if you write first hearing, no problem. You can write preliminary hearing, no problem. Mean where the PO and the CO both are available, the IO in the preliminary hearing is required to ask mandatory question from the CO. A, whether he has received the copy of the charge sheet, whether he has received or not, but this is a mandatory question required. Second question which is required to be asked from the CO is whether he accept or deny the charges, irrespective of the fact that he has already denied the charges to the disciplinary authority. You are not bothered. You are starting the thing afresh. Now, there is a situations where the CEO may say, I accept the charges, but my commissioner told me to follow it. One inspector or a customs superintendent can say, sir, I did it. I cleared this because my commissioner told me to do it. I will save you if you problem is there. The question is whether such a admission should be relied upon by the inquiry officer for the purpose of acceptance of law. Should the inquiry officer should rely upon such a kind of admission which is conditional admission. Conditional admission should not be taken into consideration because it is a condition. The admission should be unqualified one, unequivocal. That is required. Otherwise, it is a denial, virtually amount to denial of the charge. So, if the charges deny the charges, then you have to ask whether you accept the authenticity of the listed document which have been listed in Annexure 3 of the charge sheet issued to the charge. Whether you accept those documents as genuine, he will say yes or no. Or if you feel that he is asking for original and originals are available, you must arrange inspection as possible through the PO for inspection of the original document. And thereafter, simultaneously, you may ask the CEO that whether you, in the preliminary hearing, whether you want a defense assistant, who can assist you in defending you, that should be asked. And then simultaneously, you can also ask whether you want any document from your side to explain your side of story. If so, you may indicate the particular document, document, or the document is relevant to the charges framed against you. This requirement is required to be fulfilled by the charge officer while seeking his defense document. Similarly, in regard to the witnesses, he can indicate a witness. The requirement is that the witness should be relevant somehow, something to the charge of the frame. Otherwise, any witness was nothing to do or nothing to say. If you have asked for inspector line with the please ask question. इसका chat box में कोई प्रश्न आया?
Shobha, you can please
Shobha.
ask.
The CEO asked for inspection of original documents which are in line with the investigating agency. The matter is pending since. See, investigating agency must have given the certified copy, if I am correct. Certified copy can be made available to him from the investigating agencies. They will made available to him. See, the documents are in the investigating agency must be the CBI normally.
Yes, sir. Right, sir.
Okay. So normally they give a certified copies. Please obtain certified copy from them and hand over to them. See.
Okay, sir.
Okay. So now the CEO is asked that if he wants document in it for his case or her case, there can also be, I mean, he should be given a time to that by which time you can get the list of your document at the witness. This is probably to be done in the preliminary hearing. This should be recorded in the form order sheet and signed from the PO and CEO should be there. Within the stipulated time, the inspection of document should be taken place as required. And then CEO, if the CEO wants a defense assistant, as per the procedure, if the CEO is allowed, he should be a retired government servant or serving government servant, that also can be allowed. The requirement is that he should be a serving or retired government servant from any department. The CCS rule says any. So if he's serving, then he cannot have more than 3 cases with him. If he is retired, he cannot have more than 7 cases with him. So that should, and then next requirement is this, because time is running short with me. With a 10 minute, I don't think I can do justice to the issue. Then if for example, the CEO has chosen X as a defense assistant, he's a serving person, but the person is not relieved by his controlling authority. My controlling authority says that I can't relieve because he needed me. I needed him in my official requirement. So the man says, sir, I want only X. He's a very competent person. He will defend my case properly. Otherwise, I will not. Rule says that it is a facility. He can, if the controlling authority of the person chosen as a defense assistant is not spared by the controlling authority, you cannot allow him to function as a defense assistant. You can ask somebody else. So that if denial of a particular defense assistant does not mean denial of reasonable opportunity. So that documents are once the document from the defense side should be collected from the custodian, made available to the CEO, and then document from then both the sides are available with the PO and the CO. Then the regular hearing may take place, where the document from the management side or the prosecution side should be marked as exhibit, state exhibit S1, S2, S3, S4, like that. Defense side, it can be defense D1, D2, D3, D4, like that. Purpose is that document from both the sides, either the management document or defense or the state document, they have to be marked, and a similar marking has to be done by all the 3 stakeholder, means that PO, CO, and IO should have the same number in terms of document and same page number, so that when you refer in the inquiry, then you should, for example, in an inquiry, there is please refer to S3, page number 4. The PO should also be link up S3, page number 4. CO should have also the same S3, page number 4. So the purpose that when documents are marked and taken on record of the inquiry, that certificate has to be recorded by the inquiry officer. After they have been marked and taken on the record of the inquiry, these documents would be used by the inquiry officer for reporting his finding for the inquiry. After this is done, then the case for recording of the evidence of the witness is to be followed. For that, regular hearing is required to be fixed. A venue is fixed, depending on the convenience of all the concerned where the witnesses are located. These days, we are doing through video conferencing. There may not be a big problem in terms of venue, because the witness or the C or the PO can join through video conference also. So then I can briefly talk about how the evidence from the witness side is important. Then question answer देना चाहिए, मौका ज्योति जी बताएं. What do you expect? Because not Within 10 minutes, I will not able to do justice with the things. This is what I want to share.
Sir, question, yeah, we will give 5 minutes for question answers. Officer.
तो मैं इसी पे थोड़ा बता के उसके बाद I will ask the question. Okay. See the point here. All the evidence is recorded. For example, the management has Prabhu Dayal is the first witness, for example. He's got first witness from the management. PO will do the examination chief of his witness, examination chief of his witness. While asking questions, the PO will not ask leading question from his witness. But the leading question means he cannot put his word in the mouth of the witness what he wants. So the answer has to come from the witness himself. So that is the requirement. That is the requirement. That is the power on the, I will say, on the presenting officer as in regard to his witness. Once he has done his examination chief, then the CO will do the cross-examination. But he can ask any question, leading question, but the only requirement is that he cannot ask any irrelevant question. Irrelevant question which are not relevant to the charges framed against him. So that after that, you see from both the side, these witnesses are recorded for management side, would be recorded first. Witness number 1, witness number 2, witness number 3, witness number 4. Cross-examination by the CO, all the witnesses. The management witnesses are over, then the defense witnesses would also be recorded. The similar way, the CO cannot ask the leading question from his witness, then cross-examination by the presenting officer of the witnesses. And the same protocol. There is one requirement for the closure of the case, the IO may ask the CO whether he wants to appear as his own witness. This facility has to be afforded to him. It is the wish of the CO whether he wants to avail or not. So if he avails, then he will be virtually a witness, and question can be asked by the defense assistant and cross-examination by the PO. This is the only opportunity where the PO gets the opportunity to ask question from the CO. So then otherwise, if he does not appear, then the IO is required to conduct general examination of the charge officer about the circumstances appearing against him. These are a general question that you have to, the impression has not to be given that as if that the IO has already prejudged the issue, that already concluded that the charge is approved. You have to say that it has been alleged against so and so in the file functions, you have committed this, but the evidence has also been led by the management or the prosecution against you. So what do you propose to say? This is a sort of a clarification which is required to be asked from the CO, whatever he wants. So after that, the inquiry would be treated as closed. The PO will be asked to submit his written brief within a specific period. A copy will come to the IO and a copy to the CO. CO will send his brief direct to the IO, no copy to PO. And thereafter, IO will record his finding and give a special report. So this is, I have rushed through. This is just a rushing through, but any question now we can.
So if we have any questions, please unmute yourself or you can put in the chat box.
चैट में डाल दीजिए, कोई दिक्कत नहीं है. Yes. All are trained in inquiry officer now? Should I ask question now? There are many people there, many people joined here. Whatever I discuss, I can ask question with regard to that. That because they are all trained, not trained presenting officer and inquiry officer now. पूछिए
सिंह सर, एक और क्वेश्चन आई वांट टू आस्क.
आप पूछ ही सकते हैं, आप तो कभी भी पूछ सकते हैं. मैं तो इन लोगों के लिए कुछ बोल रहा हूँ, बोल रहे हैं.
लेट देम आस्क.
हाँ बोलिए. मैं तो चाहता हूँ कि आप तो आपसे तो कभी भी बात हो जाएगी, कोई दिक्कत नहीं. ये अदरवाइज आपकी कोई प्रश्न से जो एडवांटेज सुन लेते हैं. जी बोलिए प्रभात जी, आप बोलिए.
Yes, sir. मतलब suppose the charge officer alleges bias against the inquiry officer. तो ये bias का provision क्या है? Like what are the basic ingredients of bias? And if somebody alleges bias, then what should be done in that case?
See, the moment IO comes to know that bias has been alleged against him, he should keep the disciplinary proceeding in abeyance and refer the matter to disciplinary authority for it. See that. Not bias has, see the point there, bias has to be based on some solid ground. See, IO, it has to be, for example, IO first of all has purposefully not giving the reasonable opportunity to the CO. Thereafter, the IO, what the discipline authority will do, it will take the views of the inquiry officer also, and also review the daily order sheet, which the procedure which he has followed. And after that, a speaking order is required to be passed by the discipline authority, rejecting or requesting rejecting the or accepting the views of the charge officer, or the inquiry officer can be changed if the bias is found there. Unfortunately, fortunately, there is one case against a very senior person of a PSU. Bias was alleged against me 3 years back or 2 years back. Disciplinary authority has not passed order so far. So this is the case also. Disciplinary authority has neither rejected or accepted. It's pending with it. So the disciplinary authority has to listen to the CO, listen to the inquiry officer, listen to the presenting officer, if depending. Then a speaking order required to be passed. And after the request of the CEO is rejected, the IO can go ahead with that. See, it is not repeatedly every time you can allege bias. The bias has to be a specific ground. There, first of all, you make a bias, you have enmity with the inquiry officer. You had a court case, you have a seniority issue, you have any ill will between both of them, there has to be solid possible ground. There has to be solid ground. Why the IO would be deemed to be biased? If you feel that IO is not following the proper procedure, is not giving it an opportunity, that has to be spelled out clearly, and that it has to be substantiated by the evidence. So if this is not there, the bias rejected, then the IO can go ahead.
So one question in the chat box. At which stage CEO can submit list of his witness and list of documents? And is it compulsory for the IO to accept this?
Yeah. Because since I rushed through it, so my answer deta hu uska. See, after in the preliminary hearing, normally we ask that whatever the document you want in support of this case, because when preliminary hearing, we give a time frame that you can ask, you can take 15 days, 20-day time to you, we give it that to ask, submit the list of the document and the witnesses, and then once it is submitted by the charge officer, it is not compulsory. I'm clarifying. The requirement of the rule is that the document should be relevant to the charges framed. If the document is not relevant to the charges framed against the CEO, the IO is required to pass a speaking order as to why he is not accepting the request of the CEO. Only those documents which are found to be relevant to the charges framed will be lowered by the office. Okay? Not all.
Hello.
हाँ जी.
Sir, I have one
So Ankit, you can unmute yourself. So there are two. Okay, Ankit, can you hear me? Yes, Ankit, can you unmute yourself and ask, please? Okay, I'll then read it out. Sir, Ankit has asked if the charge inspector or superintendent states that they were instructed by the commissioner in writing, will they be cleared of the charges or they too will be charged even after that?
Sir, if the charge is inspected and the students are they are instructed by the commission in writing, will be cleared of the charges or they will charge even that. They have got something writing from the commissioner.
Yes, sir. That is what he meant. He said his mic is not working. So what he's saying is that they were instructed by the commissioner in writing.
To follow, yes, then that evidence can be produced in the inquiry. Then evidence can be produced, and if it is found that it is really this, I mean, the CEO has been instructed by this competent authority to follow a procedure, then the IO, the CEO cannot be, I mean, faulted if the evidence is like that. Evidence has to be evaluated thereafter by the inquiry officer, whether that particular document is genuine. First of all, that has to be, authenticity has to be verified. Because anybody can say, I mean, this document. If document is genuine, document produced in the inquiry, and then the IO can take note of these documents in totality. So it can be taken. It's a very important document. If the writing it is produced, it can absolve the charge officer because he has followed lawfully. He has followed the law, I mean, order of his period.
Any other question?
Hello, good afternoon, sir. I am Ravinder Kumar Superintendent from Ahmedabad.
Yes.
Sir, my question is that in a particular inquiry, there are 4 or 5 witnesses which are not appearing after repeated summoning to them. So, can we drop those witnesses?
Okay, you are talking in terms of you are talking as a presenting officer. You are in capacity of presenting officer and the management witness.
Yes, sir.
I tell you, you have to see what is the relevancy of those witnesses, how important those witnesses are, and why they are not appearing. If they are government servant, then you can write to the controlling authority. I mean, that because ultimately, if the evidence is important, it is obligatory on the part of the government officials to appear in the inquiry. They cannot run away from. You must first first of all, verify whether their evidence is important. Number 2, you take up with the competent authority through the your authority so that they participate. If they do not participate, then they are liable to be dependent. Departmental action can be taken against them for not participating. So you must take up. You should not drop. Simply, if you feel the witnesses are irrelevant, nothing to depose, any useful material, then you may take the approval of your higher authority or the civil authority report. It all depends, but you should not blindly mechanically act. It is because they are government servant. If they could be retired person, then we can accept that because they are not joining it.
But in this case, they are private persons.
They are private person. That private persons, if you can motivate them, try to. If you can't, if you feel that evidence is very important, कोशिश करो. नहीं आता, you can't help it because you cannot force private people.
Yes,
But how much evidence you would be losing, that also has to be evaluated. Dropping a witness should be a very careful exercise because management case likely to be affected adversely at times.
yes. Thank you, sir.
Okay. One more question we'll take, sir. It's in the chat box. What action should be taken if the witness is private party and responding to notices?
What action should be taken if the witness is private party and responding to notices? Private parties, no, what is the meaning of this? What action should be taken if the witness is private party and responding to notice?
Kamlesh Kumar, can you finish?
Asking na, witness is not responding.
Witness is not responding. A private, as we discussed, that private party, you can't force point amendment beyond a point. You can motivate, you can try your part. I mean, that is the only somehow you can try to bring. उनको technically private party को TAD का issue होता है. And if TAD is insured, you give them, book their ticket, and make them comfortable, bring them.
Or
then
now they can even deploy online also, na? We can have an online session.
Yes, कहीं online, कहीं वीडियो कॉन्फ्रेंस जगह पर वहाँ ले जाओ, वहाँ चाय वाय पिलाओ उनको, जरा भाई साहब आप आइए, गाड़ी से लेके आइए, को लेके आ जाओ, घर से लेके आ जाओ, थोड़ा सा करना पड़ता. This is again exercise which has to be done. You give them a little comfort, because why should, after retirement or for example a private person do not participate, somebody can go to them, make them comfortable. Sir, I will come and pick up you, I will drop you back. So this kind of, if he is an important person where his evidence is very important, we must make effort to see that they join for this. It should not be a mechanical exercise. It should be a very careful exercise. This is what I want to say.
Any more questions we have? Otherwise, then we will. Merida?
Yes, sir. With your permission, can we wind up the session, sir?
I'm open. If you can wind up, it's okay. Thank you very much, because ultimately, if the people have no question to ask, this is problem. पता क्या है? ये online में दिक्कत होती है. If people are physically available, you can persuade them. See, this is the disadvantage of a online exercise.
But things are today. Now we had discussed so many questions and answers. So the actual purpose of vigilance dialogue वो आ गया, है ना?
आ तो गया. मेरी satisfaction नहीं हुई.
नहीं, आपको अभी और मौके मिलेंगे ना. अभी आपको
satisfaction होती है, लोग सब विजिबल हो सामने है. मैं बड़ी स्क्रीन पे कहीं ज्वाइन करना चाहता हूँ, लोगों में सबसे बात करते हैं.
बुलाएंगे तो बॉम्बे बुलाएंगे और ऑफलाइन कोर्स कराएंगे आपके वहाँ पे जो है. That will be the nice idea जो है.
अच्छा तभी लगता है सब लोग ज्वाइन करें. प्रश्न पूछने तो अच्छा लगता है.
Yes.
See, tell you, I have practically a lot of things come to your mind all of a sudden, and then you can read unless you discuss the practical situation. Theory nobody is interested in it. It's only practical issues which are important.
Correct.
Sir, so on behalf of Principal ADG NACIN Mumbai Shri Prabhat Kumar, sir, Additional Director Ms. Jyoti Agrawal, ma'am, and all the participants, I would like to express my sincere gratitude for your insightful and informative online session and taking us through the various aspects of conducting of departmental inquiry, interspersed with real-life instances, and also, sir, for answering the queries and doubts raised through this forum. Your session has undoubtedly enhanced our understanding of the topic, and I'm sure it will be beneficial to the many officers who have logged in today. So thank you once again, sir, for your valuable contribution to our learning experience. I would also like to thank our participants for being attentive and also for your queries. So with that, sir, I would like to thank all of you once again, and I would request you to please join in at our next session next week. With that, thank you all and have a good day. Thank you, sir.
Thank you much. Have a nice day.
Thank you so much.
Thank you, sir.
Thank you, sir. Thank you all.
Thank you, Singh sir. Right.
Marita, you can also post a mail ID on the chat box so that if anyone has any questions later on, they can send us a mail.
Yes, ma'am. I'll do that.